Today, the subcommittee is meeting to consider two bills, H.R. 6062 and H.R. 6273. They are the vehicles for issues of importance to two of our territories in the Pacific, American Samoa and Guam. I would like to thank you for traveling as far as you have to be with us. I would assume that the weather is a little bit different than what you're used to. It's a little different than a lot of us are used to, so thank you for being here. H.R. 6062, sponsored by my colleague, Ms. Radewagen, would give the Secretary of the Interior the sole authority to approve amendments to the American Samoa Constitution. Prior to 1983, American Samoa was under the realm of the executive branch, specifically the Secretary of the Interior, when it came to constitutional changes and other changes to the governing authority of the territory. In 1983, following ongoing tensions between then Secretary of the Interior and the American Samoan government, then American Samoa delegate Fofo Iose Fasunia urged Congress to amend the standing law. As a result, Congress amended federal law, Section 12 of Public Law 98-213, to prevent the American Samoan Constitution from being changed without an act of Congress. While there have been multiple attempts to revert back to the pre-1983 statute, the change still remains in place today. H.R. 6062 would reverse course and grant the President of the United States and subsequently the Secretary of the Interior the sole right to approve any amendments to the American Samoan Constitution without the need for congressional approval. Our second bill on today's agenda, H.R. 6273, sponsored by the gentleman from Guam, Mr. Moylan, the Guam Host Community Compensation Act, would extend annual compact impact grant funding, require the Secretary of the Interior to enter into a memorandum of understanding regarding incarcerating certain felons, and establish residential requirements for migrants of the Freely Associated States, or FAS. Under the first Compacts of Free Association, or COFA, citizens of FASs who legally work and reside in the U.S. were eligible to receive U.S. federal benefits available to any legal permanent resident. This eligibility was lost under the 1996 Personal Responsibility and Work Opportunity Reconciliation Act, or PRWOR. As a result, U.S. states and territories have had to shoulder the financial costs of hosting legal permanent residents from the FAS. The 2003 COFAs provided Guam, American Samoa, the Commonwealth of the Northern Mariana Islands, and Hawaii with $30 million in annual grant funding, otherwise known as Compact Impact Grants. These grants were authorized through fiscal year 2023 and were used to address increased demands placed on health, educational, social, or public safety services as a result of COFA. H.R. 6273 would extend and authorize this authority through fiscal year 2043 while removing Hawaii's eligibility in this program. This authority was not extended under the recent iteration of the COFA. Instead, the language introduced a new provision known as Compact Impact Fairness. The Compact Impact Fairness provisions would return federal benefit eligibility for FAS migrants to pre-1996 social benefit levels. H.R. 6273 would also require the Secretary of the Interior, in coordination with the Attorney General, to enter into memorandums of understanding with each state, territory, and the District of Columbia to require any FAS migrant in the U.S. who is convicted of a felony to be housed in a federal correctional facility. Finally, H.R. 6273 would bar any FAS migrant from obtaining non-immigrant residency status in Guam unless they can provide proof of employment or academic eligibility and show proof of a residential address. I look forward to a robust conversation on these two bills, and I want to again thank both sponsors for their dedication to those they represent. I also want to take the time to thank our witnesses for being here today, most of which have traveled halfway around the world to be here. We appreciate you being with us in person and look forward to your statements. Before I yield back, I do want to express my disappointment that despite receiving an invitation to testify here today, the U.S. Department of Justice declined to be here. I hope that they will, however, engage on these important issues moving forward. And with that, I yield back. H.R. 6062 would grant the President and subsequently the Secretary of the Interior the sole responsibility of approving any amendment to the American Samoan Constitution. The current process under existing law is that the Secretary of the Interior must approve amendments and then Congress. In 2022, the citizens of American Samoa supported several amendments to their constitution, and they have been submitted to the Department of Interior for approval. Congress has yet to receive these proposed constitutional amendments. Mr. Nakoa, can you provide the committee an update on DOI's review of these amendments?
Thank you for the question, Chair Hegeman. The department has indeed received the 5 approved amendments from the governor as transmitted in I forget the date. However, after consultation or conversations with both Governor Mauga and his staff, as well as Representative Radewagen and her staff, the consensus decision has been to pause the ultimate review in order for Congress to act on H.R. 6062.
Okay, so my understanding is you're not going to be moving forward with those amendments at this time?
At this point, that's the request and that's our intention.
Okay. Compact impact grants have provided $30 million annually in grant funding to the Pacific Territories and Hawaii since fiscal year 2004. This program expired in fiscal year 2023, and the Biden administration's COFA proposal did not reauthorize compact impact grants, but instead included compact impact fairness provisions. My question is, why does the administration believe that the compact impact fairness provisions are a better solution to addressing the impact of the compacts?
Thank you for the question. As mentioned in, I guess, the hearing about the Compact Impact Fairness Act earlier and in several other hearings that we've had on the compacts, the position of the administration is that the Compact Impact Fairness Act is a more holistic, enduring solution for addressing the impacts on host states and territories from the immigration or migration provisions of the compacts. And so with that, they also, the benefits would also follow the FAS citizens wherever they're choosing to live, as opposed to just staying with the 4 identified jurisdictions in the Compact Impact Grant authorized in 2003 under PL 108-188.
Well, Mayor Ale, do you agree that the compact impact fairness is the best solution for Guam?
I do not agree.
Okay.
I do not agree.
Would you please explain?
In my testimony, I talked about all the expenses that we endure as an island and how our economy is affected. And so I don't believe that it gives us a fair share at what we really should be receiving in order to take care of the migrants and our own people.
So do you believe that the number needs to be higher than the $30 million?
Yes, ma'am.
Okay, but what about the way that it is being addressed through the compact impact fairness rather than through the compact impact grants? Is there any difference between the two?
Unfortunately, I won't be, but I cannot answer that question.
Okay, thank you. I have a couple of questions for Lieutenant Governor Ale. If H.R. 6062 becomes law, Congress will lose part of its oversight authority. And while Congress still has the authorities granted under the Territory Clause of the U.S. Constitution, it would no longer be directly part of the American Samoan constitutional amendment process. Can you explain to us why you believe that this is still the best path forward for American Samoa?
Thank you, Your Honor. It is the best process because currently we have 5 amendments, and if approved by the Secretary, we will have to take it through Congress. And as mentioned by Delegate Radewagen, it's unclear, well, number one, Congress has no obligation to take up our amendments. And so we could be waiting for a very long time before these amendments are approved. Congress has so much more important activities that's on its table. The issues that we talk about in our local constitutional amendments are local issues, and it should be resolved locally. We have developed a very good relationship with the Secretary for over many years, and we believe they will give more attention to our issues than
Okay.
Congress, so that's the best way forward.
Mr. Jennings?
Yes.
If I understand your testimony correctly, you disagree with that position. Is that correct?
Madam Chairman, I, only for the fact that there's no assurance that the rights of all Americans, including Native American Samoa, comprising of the lineal descendants of Tutuila, Manua, and Swains Island. It's not part of the mandate that we feel that DOI is under, based on the discoveries with the executive order. It only recognizes one resolution, and that was the Ratification Act of 1929. But it failed to recognize the 1925 resolution that made Swains Island, joint resolution of Congress that made Swains Island part of American Samoa.
Okay.
And rather than pointing fingers, I have to say, that's where the problem is.
Okay, perhaps we can figure that one out.